Hello everyone. Recently, the Law Commission recommends to amend a patent anomaly which is present in Order 7, Rule 14, Subrule 4, which states that documents relied on plaint. While filing the plaint, the plaintiff has to give a certain lists of document along with the plaint. Namely, as per Rule 14, Subrule 1, where a plaintiff sues upon a document or relies upon document in his possession or power in support of his claim, he shall enter such documents in a list and shall produce it in the court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaint. Nextly, according to Rule 14 and Subrule 3, a document which ought to be produced in court by the plaintiff when the plaint is presented or to be entered in the list to be added or annexed to the plaint, but it is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. So, Order 14, Order 7, Rule 14 and Subrule 3 mandates that if it is if the document, the list of the documents are not filed along with the plaint, then without the leave of the court, such documents in the latter stage of the suit will not be appreciated in the evidence. Similarly, Rule 4 mandates, Subrule 4 gives an exception to this rule, where it states that nothing in this rule shall apply to document produced for the cross-examination of the plaintiff's witness or handed over to a witness merely to refresh his memory. So, if such document is kept to cross-examine a witness, and also if such documents is to be used for refreshing the memory of a witness, which is prescribed under 159 of Evidence Act, where a person or where a witness can refer to an evidence to refresh or recall his memory. For that purpose, the document need not to be filed at the time of filing the plaint. Under these two provisions, under these two conditions, evidence is to be appreciated, can be appreciated with the leave of the court at the latter stage of the suit, but otherwise it will not be appreciated. The anomaly here is that in the same manner, if we refer to the written statement, Order 8, Rule 1A, there we will find that similarly, while filing the written statement, the defendant has to file a list of documents which he is relying upon. But similarly, there are also two exceptions we can find, namely under Rule 1A, Subrule 4, nothing in this rule shall apply to documents produced for the cross-examination of the plaintiff's witness or handed over to a witness merely to refresh his memory. Here we will find the phrase plaintiff's witness, and under Rule 14, Subrule 4, you will also find the same phrase termed as plaintiff's witness. So, the anomaly you can clearly distinguish between Rule 14 and Rule 1A of Order 8 and Order 7 respectively. It is actually an error made by the legislature while drafting the CPC. In a leading landmark judgment of Salim Bar Association versus Union of India, it was categorically held that the plaintiff's witnesses as given under Order 7, Rule 14, Subrule 4 will be deemed as defendant's witness. If we strictly interpret the phrase of plaintiff's witness as given under Order 7, Rule 14, it is simply making a sense that somehow the plaintiff can foresee or can predict which witness will turn hostile in the latter part of the suit, which is quite impractical. That is the reason why Supreme Court has categorically held in the leading case of Salim Bar Association versus Union of India the plaintiff's witness has to be construed as a defendant's witness. After almost 16 years also, the legislature has not yet amended the provision. That is the reason why the Law Commission recently recommends to amend this patent anomaly present in order. Again, Salim, you as a student of law, we should thoroughly once go through the entire judgment of Salim Bar Association versus Union of India, where we can also find that the 30 days period given under Order 8 to file the written statement is actually not mandatory, rather a directory in nature. There are also a catenary judgments or catenary issues were discussed. I strongly recommend you to individually go through all the issues covered in the landmark judgment of Salim Bar Association versus Union of India. And that's all for today. We'll meet in the next episode. Thank you.